Dear viewers, welcome to yet another episode on Course of Property Law. I, Dr. Vijeta Singh from SS Mania Law College, Jalgaon, Maharashtra. Today we are going to discuss registration of lease and benefits along with the rights and liabilities of the lessor and the lessee. Let's start with the introduction. As you might have seen in the previous episode, lease of an immovable property can provide some benefits like low initial payments, tax reduction, low risk, etc. In a simple terms, we can understand that lease is simply the relationship between the landlord and landlady or her tenants. Lease is a form of contract between these parties for a fixed period of time. This relationship between the owner and their tenant arises when the owner of the immovable property gives his property to another person for a fixed period of a time and a contract was made between them. Thus, this contract includes the term like amount of the rent, rate at which it is collected, duration of the lease, purpose of the lease, etc. Lease is a transfer of an interest in the property for a stipulated period of a time without transferring the ownership of that property. In a lease, right of possession is transferred instead of the right of ownership. Lease of immovable property is governed by the Transfer of Property Act and it is given from section 105 to 117. Let's see the definitions. Section 105 of the Transfer of Property Act 1882 gives the definition for lease, lessor, lessee, premium and rent. It defines that a lease of immovable property is a transfer of a right to enjoy such property made for a certain time, express or implied, or perpetuity in consideration of a price paid or promised or of money, a share of crops, service or any other thing of a value to be rendered periodically or on a specified occasion to the transferor by the transferee, who accepts the transfer on such terms. For entering into a lease agreement, there must be two persons, namely lessor and lessee. Let us see who is a lessor. Lessor is a person who leases or lets the property to the another person, means transferor is a lessor or landlord. Lessee is a person who holds a lease of a property. Transferee is a lessee, means tenant. Premium. Premium is the amount to be paid. Rent refers to a tenant's regular payment to his landlord for using his property or a land. Registration of lease. The method of making a lease by parties has been mentioned under section 107 of the Transfer of Property Act 1882. Under the provision of the Registration Act 1908, certain agreements and the sale documents are required to be registered with the relevant government authorities in order of those agreement or documents to hold a legal value. This is done in order to maintain an official record of taxable deals and sales. Section 17 of the Registration Act 1908 has made it clear as to what documents are compulsorily required to be registered with the District Registrar Office, and this list includes lease deeds of immovable properties, the tenure of which exceeds 1 year. The exceptions for lease deeds tenure below 1 year is mentioned in the subsequent section 18 of the Act. So, in brief, the registration of lease deed and all relevant laws regarding such matters are covered jointly under the Transfer of Property Act 1882 and the Registration Act 1908. Now, question comes, why should lease deeds be registered? The basic tenets of laws relating to the transfer of immovable property and the Registration Act covers the legal implication that non-registering of a lease deed can cause, but the important and positive thing to note is that registration of such deeds if they are made for 1 year or over 1 year, gives a legal backing to the agreement between the parties, thus creating a cause of action in case of a disputes and helps to protect the interest of the parties. So, in short, it protects the interest of the parties to a lease agreement. It provides legal backing and conformity to the deal by making a registered deed an admissible court document as well as collateral transactions. Legal implication of a non-registration of a lease deed. Firstly, an unregistered lease deed can incur fines by district sub-registrar up to 10 times the original value of the stamp duty required in the case it comes to the notice of the authorities. The other basic implication of a non-registration are given under section 49 of the Registration Act 1908. The gist of this section implies that a lease deed which was legally required to have been registered, which is not so, would not be acceptable or admissible as evidential material in a court of law. Another important implication is the validity of such a lease deeds. This position of law has been elaborated upon in the case of Anthony versus Casey Itoop and Sons and others. 21st July 2000, herein the Supreme Court of India observed that in the presence of three relevant statutes, section 17 and 49 of the Registration Act and section 107 of the Transfer of Property Act, the position became clear that a lease deed which is unregistered, which was supposed to be compulsorily registered, will not result in a valid lease agreement. However, the court also observed that even in the absence of such legal validity due to the non-registration, a lease agreement would be assumed to be in existence based on the conduct of the parties, that such an unregistered lease deed will be considered to be retained on month-to-month basis instead of a fixed tenure. Very recently, in the 2016, the Supreme Court in the case of Park Street Properties Private Limited versus Deepak Kumar Singh and others stated that if the deed remains unregistered and the action of the party shows that a lease agreement is active, then that lease agreement would come under the provisions of section 106 of the Transfer of Property Act, which means that this type of lease deed would be month-to-month basis and will follow all the regular rules in that manner. Effects of non-registration. The Registration Act and Transfer of Property Act lays down what the effects of non-registration of lease deeds that are required to be registered are. First, the Registration Act 1908. The Registration Act mandates that an unregistered lease deed cannot affect any immovable property or be received as the evidence of any transaction affecting such property. Section 49 of the Registration Act puts forth the consequences of non-registration of documents which are required to be registered mandatorily. Section 49 lays down the fact that non-registration of the property will cease to have any effect on immovable property. Lease deeds of this manner will not be considered as a evidence of any transaction affecting such property. However, there are certain limited purposes. Evidence of a contract in a suit for specific enforcement and as a evidence of any collateral transaction that is not necessary to be affected by a registered instrument in Atuluru Saraswat Amma versus Atuluru Paddeya and others. In 1922, it was clarified that the importance of affect any immovable property and the term affect was held to be an inclusive term. Thus, assuming a lease deed that is to be registered isn't, then the lease deed will not establish leasehold directly for the lessee. The Honorable Supreme Court in the KB Saha and Sons Private Limited versus Development Consultant Limited held that an unregistered document is not accepted as the evidence. An unregistered document can be used as the evidence of collateral purpose under section 49 of the Registration Act in certain cases. A collateral transaction must be void of the transaction to effect which the law mandate registration. A collateral transaction has to be a transaction that, irrespective of whether the document is registered or not, is unaffected. Next, if a document is inadmissible in evidence for a lack of registration, none of its term can be admitted in the evidence. In Bharat Petroleum Corporation Limited versus Khaja Middat Noor and others, the Supreme Court stated that a lease for a period of more than 1 year can be created only by a registered instrument. If there is no registration, then the lease shall be month-to-month lease. Hence, it is established that a lease exceeding the period of 1 year can only be validated by virtue of registered instrument. There can, however, be an assumption as to the existence of the lease based on the document of the party. Such assumptions will be administered and regulated by the provisions laid down by the Transfer of Property Act. Such leases will be valid on the monthly basis that can be declared as terminated by either party with 15 days notice. Time limit for registration of lease deed. In Registration Act 1908 under section 23, it is mentioned that any document other than will has to be presented before the relevant authorities for their registration within the 4 months from the date of their execution. This is necessary particularly for commercial or corporate lease agreement that involves clear-cut tenures and fixed sums of money with a higher stakes. If such an agreement is not registered in a time and is declared to be invalid, then it gives the parties a cause of action to pull out of the lease agreement following the provisions of section 106 of the Transfer of Property Act 15 days notice prior to termination. In the case of Ram Singh Santram versus Jasmeer Singh, Hardit Singh and another, a commercial deed for the lease was considered to be inapplicable for registration by the Punjab Haryana High Court as a period of 8 months has been elapsed since its execution. A similar instance was taken by the High Court of Delhi in the case of Aspire Investments Private Limited versus NextGen Edu Solutions Private Limited in 2015. Here, the lessor's building floor was leased for the purpose of running a school, but the lease failed to pay the rent on multiple occasions, which led the lessor petitioner to send in an eviction notice to the defendant lessee. When the matter came before the court, it was found that the lessee had also not registered the lease deed for the building floor for a period of more than 10 years. The court held that such a long delay in registration was not a valid action, as running a school in the leased building was not feasibly a monthly rental process. Importance of registration of a rent deed. When it comes to commercial real estate transaction, the importance of proper documentation cannot be overstated. One crucial step in securing your investments as a landlord or a tenant in a commercial property is registration the lease agreement at the land registry. While this process may seem like just another a bureaucratic requirement, it offers a numerous advantages and protections for all parties involved in. Legal clarity. One of the primary reasons for registering a commercial lease is to establish a legal clarity. By recording the lease at the land registry, you create a publicity accessible record of the lease terms and the parties involved. This helps prevent disputes and misunderstanding in the future, as anyone can review the lease's details. It also ensures that all parties are aware of their rights and responsibilities. Priorities of interest. Registering a lease grants priority to the registered interest holder. This means that if there are multiple claims or disputes concerning the property, the registered leaseholder's rights will take precedence over unregistered investments. This can be particularly important in cases where the property owner faces financial difficulties or other legal challenges, as the registered lease will be protected. Protections for tenants. Tenants benefit significantly from the lease registration. If a landlord sells property or encounters financial issues leading to foreclosure, the registered lease remains valid. This safeguards the tenant's right to occupy the premises for the duration specified in the lease, providing security and peace of mind. Third party interest. In some cases, third parties may attempt to assert rights over the property, such as lenders, creditors or other individuals with the claims against the landlord. A registered lease will serve as a notice to these parties that the property is encumbered by lease, protecting the tenant's right to occupy the premises despite external claims. Future property transactions. For landlords looking to sell their commercial property, having registered lease in place can enhance the property's marketability. Prospective buyers are more likely to be attracted to a property with established lease agreements, as they can assess the rental income and tenant stability. This can potentially increase the property's value and make it easier to sell. Lease term clarity. Registering a lease also provides clarity regarding the lease terms. It allows anyone interested in the property to determine when the lease will expire and whether there are any renewal options. This transparency can be essential for planning purposes and making informed decisions about the property's future. Obeying law always goes in one's favor. In case of any dispute, the party who has fulfilled all the legal requirements has a greater chance of winning the case. We explained to here the provisions in law for registration of rent agreement and the importance of registration. It stands as follows. Transfer of Property Act 1882 and the Registration Act 1908 deal with the registration of rent deeds, lease deeds. Registration of documents means recording the ownership of the property in government records. It is mandatory to register the lease deeds, rents agreement if rent deed is for a period of 1 year or more. An agreement where the rent is fixed for a short term less than 1 year is a rental agreement. An agreement where the rental amount is fixed for a longer duration more than 1 year is a lease agreement. Under the Transfer of Property Act, it is provided that the lease deed for a period of more than 1 year or reserving a yearly rent can be made through a registered instrument only. Registration of a rent agreement if a rent or a lease is for more than 1 year has been made compulsorily under the Registration Act 1908. If the rent deed is for a period of 11 months, it is not compulsory to register the rent deeds. Importance of a rent agreement registration. Registration of a document. Registration of a document helps to maintain discipline in the property transactions. The registered document is a legally binding and violation of its terms and condition invites the legal actions. Benefit of registration area. Benefits of registration are: first, legally defines ownership rights. Second, strengthens one's claim over the property. Third, helps to safeguard the owner's right and interest. Fourth, it gives notice to all others about the ownership of the property. Ownership becomes certain. Fifth, the landlord is more secure if the agreement is registered. Sixth, without registration, the new owner is not legally recognized as the owner. Rights and liabilities of lessor. Section 108 of Transfer of Property Act. Rights of the lessor are as follows. A lessor will have a right recover its rent from the property which is leased by him. Next, lessor having a right to take back his property's possession from the lessee if any breach of condition is done by lessee. Next, if there is a damage to the property which is leased, then the lessor having a right to recover the amount of damages from the lessee. Next, on the termination of the contract of the lease, the lessor having a right to take back his possession from the lessee. Now, liabilities of the lessor. Section 108 clause A, the lessor is bound to disclose the entire material defect relating to the property which are leased with the former intended use of which the former is and latter is not aware. Section 108 clause B says lessor is bound to request the lessee to put him in a possession of his property. Section 108 clause C, lessor can make a contract with the lessee that if he pays the rent letter on which is reserved by the lease and performs all the terms and conditions mentioned under the contract which binds the lessee and then the lessee may hold the property during the specified time without the interruption. Rights and liabilities of the lessee. Rights of the lessee. Section 108 clause D, during the continuing period of lease, if any accession is made, alluvion for the time being in force, then that accession or area will be taken under such lease. Section 108 clause E, during the continuing period of lease, if a material part of the property is destroyed wholly or partly through by fire or by flood or by war or by violent act of the mob or by any other means, and it becomes permanently unfit for the use for which it is to be rendered, then it becomes void at the option of the lessee. However, if the injury is caused due to the default act of the lessee, then he cannot avail himself from the benefit of the provision. Section 108 clause F, during the continuing period of a lease, if the lessor avoids to make any repairs to the property which he is obliged to do on a reasonable time even after notice, and if such repair is done by the lessee himself, then he has a right to deduct such expenses from the rent or can recover from the lessor. Section 108 clause G, if the lessor avoids making any such payment which a lessor is bound to make, and if such payment is recoverable from the lessee or recovered against the property, then the lessee has a right to recover it from the lessor or can deduct it from the interest of the rent. Section 108 clause H, lessee having a right to remove all such things which he has attached himself to the earth, provided that lessee has to leave the property in such a state in which he has received it. Section 108 clause I, When a lease is of such a duration which is not specified by any means except the fault of the lessee, he or his legal representatives having a right to collect all the crops which is planted, shorn or growing by the lessee at the lease property, and they are free to ingress and egress from such property. Section 108 clause J, lessee having a right to transfer the property absolutely or any part of his interest by way of sublease or through mortgage, but by such reason a lessee cannot by any means seizes himself from the liabilities which are attached to the leased property. Liabilities of the lessee towards the property or against the lessor. Section 108K, lessee is under obligation to disclose all the material facts which likely to increase the interest of the value which the lessee and the lessor is not aware about. Section 108 clause L, lessee is under obligation to pay the premium or rent to the lessor or his agent on the reasonable time. Next, section 108 clause M, lessee is under obligation to keep the property in a proper condition and on the termination of the lease, restore all such goods in such a way as it was at the time when he was in possession. Section 108 clause N, if lessee is aware about any proceedings against the property or any encroachment or any interference is done, then lessee is under obligation to give notice to the lessor. Next, section 108 clause O, lessee is having a right to use the asset or goods which are placed in the property as a ordinary prudence man and use it as it his own, but he is under obligation that he should not use or allow any other person to use the property in any other way or a purpose other than the purpose for the property is leased. Lessee cannot without the consent of the lessor taken out any structure permanently off or on the property except in the case of agricultural purpose. Section 108 Q, on the termination of the lease, lessee is bound to give the possession back to the lessor. To conclude, registering a lease deed in property related transaction is a prudent as well as a crucial step to safeguard your interest in case of a legal predicament, and as such should not be avoided even if the property transaction in question is a small scale in nature. The prospect of law in this regard are quite streamlined, and the process, though tedious on a ground level, is mostly hassle free, especially since the introduction of online registrations and appointments in many states. The rights and liabilities of lessor and lessee are critical aspects that govern the dynamics of a property lease. The rights of lessor includes entitlement to property, accretions and the collection of a rent without interruptions. Liabilities of lessor involve disclosing material defects in the property and ensuring the lessee's peaceful enjoyment. On the other hand, lessee rights encompass charging for repairs, removing fixtures and benefiting from crops during the uncertain lease duration. Liability consisting of disclosing material facts to the lessor, paying rent on time, maintaining the property and restoring possession after the lease ends. Understanding these rights and liabilities, lessor and lessee is crucial for successful and harmonious leasing relationship. This is all for today's. Thank you. Thank you very much.